So when a loved one takes their final breath, I think we all kind of expect time to just stand still. Like we expect this period of quiet grace.
Right, a chance to process the sheer weight of what just happened.
Exactly. But the reality is actually terrifying. The exact second a patient dies, this hidden legal and medical clock just, it starts ticking immediately.
It really does, and it can instantly turn this quiet, grieving hospital room into a high-stakes battleground.
Yeah. You go from grieving a profound loss to suddenly being forced to navigate this massive, just unyielding machinery of the medical and legal systems.
And if you don't know exactly how that machinery works before you get caught up in it, I mean, it will simply run right over you. It can erase everything your loved one wanted.
Which is exactly why we're doing this deep dive today. We've got this incredibly compelling stack of sources in front of us. We're looking at legal strategy frameworks, blueprints for charitable foundation, strict medical autopsy protocols, and even highly detailed clinical trial notes.
It's a massive amount of documentation.
It is. And our mission today is to explore this huge collision of rare cancer research, probate law, and family conflict. And we're looking at it through one very real, very intense case.
Yeah, the story of Jennifer Isake Lockette Holloway. She was a 55-year-old former family nurse practitioner who passed away from a rare cancer, and we're also following her 69-year-old patient advocate, Michael Walker.
Right. And it's a case that forces us to look straight at the sheer mechanics of death.
It really serves as a playbook for you, the listener, on how to handle the business of dying, really, before a crisis hits your own family.
The business of dying. I mean, the best way I can describe those moments right after death is to compare it to like a massive closing vault door.
Oh, that's a good way to put it.
Yeah, because when a patient passes, this heavy steel door just starts swinging shut. And once it locks, all the physical evidence, the medical truth, the legal rights, they might be locked away in the dark forever, unless someone acts incredibly fast to prop it open.
And to understand why the immediate aftermath in Jennifer's case was so critical and why her advocate, Michael, was fighting so hard to keep that vault door open, we have to look at what she was actually carrying inside her body.
Right.
She was essentially a biological time capsule of invaluable scientific data.
Let's get into the cancer itself, because that's key here. Jennifer was fighting gastrointestinal stromal tumor.
Exactly, GST.
And this isn't your standard well-mapped cancer that behaves predictably. It's super rare.
Yeah.
And it's driven by very specific genetic mutations. The sources specifically mention the KIT or PDGFRA mutations.
Yeah, and when a cancer is driven by those specific genetic anomalies, standard broad-spectrum chemotherapy is often completely useless.
Wow, really?
Yeah, it's like, think of it like trying to pick a highly specialized biometric lock with like a rusty skeleton key.
It just doesn't fit the mechanism.
Right. Patients have to rely on targeted therapies that interrupt the specific signals telling the cancer cells to divide.
But cancers are smart, right? They're highly adaptive.
Oh, totally. They mutate. They learn to build resistance to those targeted drugs. And once that first line of defense fails, patients are left with very few options.
Which is exactly why Jennifer entered a phase 1 clinical trial at UCLA. This was conducted by Dr. Arun Singh and Kura Oncology.
Right. This was absolute cutting-edge precision medicine.
Yeah, the trial was testing an investigational drug called ziftomenib combined with a standard drug called imatinib. So this wasn't a standard protocol at all.
No, not at all. It was designed specifically for patients whose cancer had outsmarted their initial treatments.
And when you enter a clinical trial at that early stage, I mean, phase 1, you're essentially agreeing to become a living laboratory.
You really are. There is intense, unrelenting monitoring. You're subjected to endless blood draws, massive imaging scans, painful biopsies.
And Jennifer, being a former nurse practitioner, she fully understood the gravity of doing this. She knew the physical toll it would take on her.
She did. But she also signed these extensive consent forms, allowing her blood, her tissue, her biological samples to be stored, coded, and analyzed for up to 15 years.
15 years. Which effectively turns her biology into a roadmap for future treatments.
Exactly. The sources actually call this patient-powered science.
Patient-powered science. I love that.
Because every biopsy, every scan, every single tissue sample from a patient like Jennifer is a critical puzzle piece for pharmaceutical leaders and researchers.
Right. They need to understand pharmacokinetics, like how her specific body process the experimental drug.
Yeah, and they need to study the biomarkers to see exactly how the tumor managed to resist the treatment. If that data is lost, the science basically stalls out.
Okay, that sounds incredibly noble, but let's be real for a second here.
Sure.
Does the family actually get a neat little folder with all those findings after the patient passes? Or does this incredibly personal data just disappear into some institutional black box?
Well, the unfortunate reality usually goes straight into the black box.
Oh, wow.
Yeah, the institution holds the data. The family does not automatically get a comprehensive summary of what the researchers found in the tissue post-mortem.
That's wild.
Right, the research just continues behind closed doors. And that is exactly why the sources highlight the absolute necessity of preservation letters.
Preservation letters.
Yes. If a family wants the medical truth, they have to demand it legally. They have to immediately send formal preservation notices to the hospitals, to the institutional review boards like Advara IRB, and to genomic testing labs like Tempus.
They have to actively ask, like, where are her samples?
Exactly. Are they coded? Have they been destroyed? What did you actually learn from her body?
And you have to have those questions incredibly fast. Because Jennifer's body held such vital research data, the precise moment she passed away triggered that ticking legal and medical clock we talked about. The one families rarely see coming.
And that clock operates entirely independently of a family's grief.
Yeah. Jennifer passed away at 2:25 a.m. on June 2, 2026. This was at a Kindred hospital following a code blue and intubation.
And the second that time of death was officially pronounced, the bureaucracy just took over.
The rules of that bureaucracy are shockingly tight, by the way. According to the documents in California, an attending physician had a mere 15-hour window to complete a medical certification of death.
15 hours.
Just 15 hours.
In that extremely narrow window, the physician has to make a critical legal distinction. They have to decide, is this a natural death or does it require a coroner or medical examiner investigation?
Let's unpack the friction between those two systems, because this is exactly where families get caught in the gears.
Right. Hospitals are highly complex logistical operations, They need to clear beds for incoming emergencies, process endless paperwork, and frankly, avoid unnecessary legal liability.
So a natural death path, like saying the patient died of expected cancer progression, allows the hospital to smoothly transition the body to a funeral home.
Exactly. But the coroner's path is totally different.
Right. That's triggered by unexpected trauma, medication errors, sudden falls, or any suspicious circumstances.
Because the coroner is looking out for public safety and criminal liability.
And for rare cancer patients in experimental trials, this distinction is everything. The sources stress the absolute importance of an autopsy to gather that final piece of scientific data.
And this is key, not all autopsies are the same.
Yeah, explain that.
If the coroner takes jurisdiction for a medical legal autopsy, the state takes over. The family doesn't get a say. They can't veto it.
Because the coroner is looking for a cause of death related to foul play or gross negligence.
Right. But if the hospital classifies it as a natural death from cancer, the coroner just bows out.
Which means if the family wants an autopsy, to find out if she died strictly from the expected GDF progression, or if there was a contributing factor like a bowel perforation, a severe toxic reaction to the experimental drug, or even medical neglect, they have to request a hospital autopsy.
Yes, and a hospital autopsy requires affirmative family consent.
They have to opt in.
Exactly. And crucially, it requires the hospital to actually have the capability to perform it or to quickly arrange the transfer of the remains to a facility that can before the tissue degrades.
It's basically like the hospital's death certification process is a moving conveyor belt.
That's a great analogy.
Yeah. Once a patient dies, they are placed on this belt. The paperwork gets signed, the body is moved to the holding area, the funeral home is called, and cremation is authorized.
Right.
And if the family doesn't actively sprint over and pull the emergency stop cord to request that hospital autopsy or demand tissue preservation, the system will just process them right out the door. The body is cremated, and the medical truth basically goes up in smoke.
But pulling that emergency stop cord requires someone to have the actual legal authority to do so.
And there it is, the catch.
Yep. The immense pressure of this ticking medical clock forces rapid, high-stakes decisions. And in Jennifer's case, this pressure collided head-on with a severe family dispute over who actually held the legal authority to make those decisions.
See, most people assume that if you have a power of attorney for your sick loved one, you're in charge. You make the calls.
Right, that's a huge misconception. A power of attorney legally terminates the exact second the patient dies. It just vanishes.
This poof, gone at 2:05 a.m.
Literally, at 2:06 a.m., authority instantly shifts. It shifts to named executors in a will, to trustees, or, by default, a legal spouse.
But the reality of the legal system is that a court hasn't officially appointed an executor yet at 2:06 a.m.
Exactly. So you enter this really chaotic, informal transition period. The legal framework simply hasn't caught up to the biological reality of the death.
The sources are very clear about the danger of this informal window. They advise having a calm protector in the family.
Yes.
In Jennifer's case, the documents mention an executor named Devi. The protector's job isn't to start, handing out inheritances. It's to quietly and methodically secure physical belongings, laptops, passwords, life insurance policies, and living wills before anything is moved, hidden, or deleted.
It is pure triage. You're locking down the estate. And the law provides mechanisms depending on the size of the estate. For example, the documents note that for estates under a certain financial threshold, California allows a small estate affidavit instead of going through the grueling process of full probate.
Okay, so it's a bypass.
It's designed to be cheaper and faster, yes, but it still requires a mandatory 40-day waiting period.
Okay, but let's look at the real world for a second here.
Sure.
Let's say I'm named as the executor in the will. I know I have a job to do. But the deceased spouse, who they were estranged from, physically, lives in the house. And the spouse changes the locks.
Right.
What actual real-world power do I have in those first 72 hours to get the living will or the passwords out of that house?
That is the nightmare scenario the legal strategy documents address. They outline a spousal estrangement risk assessment.
Okay, let's unpack that.
Being estranged from your spouse isn't unlawful, obviously. People separate all the time. But if the spouse uses their physical proximity to block access to medical care before death, or intentionally conceals financial documents, or ignores the patient's written advance directive after death, that changes everything.
It stops being just a private family argument and becomes a massive legal liability.
It absolutely opens the door to intense probate litigation. You start seeing claims of undue influence, financial elder abuse, or the need to petition the court for a special administrator who can legally force the doors open to secure the property.
But getting a court date takes time. A judge doesn't just hand that order out in an hour.
No, not at all.
And while you're waiting for the court to look at your petition, that conveyor belt to the crematorium is still moving. And the laptops might be getting wiped clean.
Exactly. And while the family is waiting for a court date to secure that legal authority, the tension doesn't just stay in court filings. In Michael's case, the pressure physically exploded.
Yeah, we need to introduce Michael Walker here. He is a 69-year-old family patriarch, a friend of Jennifer's for 28 years, and her designated patient advocate.
And according to the documents, Jennifer specifically instructed Michael to help secure her living will and her files because she anticipated pushback from her spouse, Carvel Holloway.
Right, so Michael is trying to execute her wishes. He's following the blueprint she laid out. But on June 6, 2026, just 4 days after she died, the conflict boiled over.
The communications show Carvel reportedly refused Michael entry to the house.
And Michael, trying to keep the peace and de-escalate the situation, proposed just meeting outside on the street to talk.
But the peace didn't hold. At approximately 4:30 p.m. on Hobart Boulevard, a physical altercation occurred. The reports state that Carvel allegedly assaulted and battered Michael.
And we need to be very precise here about the evidence the sources provide.
Yes, absolutely.
The documents include photographs from the scene. These photos show police officers, emergency responders like a fire and paramedic vehicle, and red staining on the sidewalk. But the legal strategy memos are very careful to note, and we must be completely objective about this, that while these photos absolutely corroborate that a severe emergency response occurred, they do not independently prove criminal guilt, motive, or who threw the first punch.
And that is a crucial legal distinction. They don't prove guilt in a vacuum, but they do prove the dispute moved from private grief into a public, documented crisis. The state was now involved.
To me, it's like Michael was acting as the designated driver. He had a predetermined safety plan from Jennifer. He was just trying to take the keys to make sure everything was handled safely and legally.
That's a great way to look at it.
But the profound confusion over legal authority, mixed with intense grief, turned a bureaucratic process into a violent situation. He was attacked while trying to follow the plan.
And this brings up the legal remedies that exist for an advocate in Michael's position.
Right. What can he actually do?
Well, if you're just two younger individuals fighting on the street over a disagreement, maybe you file for a standard civil harassment restraining order. But Michael is 69 years old. California has a specific legal lever for people over 65. It's an elder abuse restraining order.
Which carries an entirely different weight in the eyes of the court, right?
It is a massive escalation in legal power. The state recognizes that a 69-year-old cannot physically defend themselves the way a younger person can.
Makes sense.
Unlike a standard civil order, this elevates the conflict from a family squabble to a statutory protection case. The legal theory here is that the violence wasn't just a random assault. It was the deliberate obstruction of lawful advocacy and the suppression of medical evidence.
Because if Michael is intimidated into walking away, the living will stays hidden. The autopsy doesn't happen. The tissue samples are destroyed. The violence basically serves to slam that vault door shut permanently.
Exactly. The elder abuse order is a tool to protect the advocate, so the advocate can safely protect the patient's legacy without fear of physical retaliation.
It's an incredible pivot, really. Instead of letting this end in a bitter court battle, the family is trying to build an institution out of it. The ultimate goal of navigating this horrific collision. You know, the violence, the probate law, the ticking medical clock, the unyielding bureaucracy, isn't just to win a lawsuit against a spouse.
No, it's to ensure that Jennifer's suffering and her immense courage in that clinical trial wasn't in vain.
The documents lay out this truly inspiring blueprint. They propose transforming this grief into systemic change by creating the Jennifer Isake Lockette GIS Cancer Research Family Foundation.
And the foundation is built on very specific pillars. There is research preservation, patient education, and a strong anti-violence accountability pillar to ensure advocates are protected.
They also draw heavy inspiration from the Simsman UCLA Center, which champions whole-person care.
I love that concept because they recognize that cancer doesn't just attack the cells. It attacks the mind, the spirit, the family finances, and the relationships.
Yeah, the disease just radiates outward, affecting every aspect of a patient's life and the lives of those around them.
One of the most practical initiatives they propose is a public guide, written specifically at an 8th grade reading level.
Which is so needed.
Right. It's designed to help families navigate the terrifying world of clinical trials. It explains what genetic mutations are, what happens to your tissue, and exactly what questions to ask the oncologist before you sign those massive consent forms.
Because medical jargon is its own kind of locked vault. If you don't understand the words, you can't protect your rights, you don't know what you're agreeing to give away.
Exactly. Creating an accessible guide democratizes that knowledge.
But what about the people taking notes in the waiting room at 2 a.m.? The ones holding the vomit bags, navigating the insurance calls, tracking the incredibly complex pill schedules.
The unsung heroes.
We spend so much time talking about the patient, the doctors, and the researchers, but the people in the background often carry the heaviest administrative burden.
You're talking about the caregivers.
Yeah.
And the foundation's blueprint explicitly focuses on them through a pillar called caregiver empowerment.
I love how they phrase that.
Yeah, the documents reframe the caregiver's role completely. They aren't just family, they are the memory system.
The memory system.
When the patient is too exhausted to think or speak, the caregiver is the one tracking the milligrams of medications, noting the side effects, fighting with the billing departments. They are the hidden infrastructure of cancer care.
And the foundation wants to empower them with structured tools. We're talking about comprehensive medical binders, legal checklists, and step-by-step guides on what to do the exact second the patient dies.
Because a binder isn't just paper, it's an external brain.
Wow, an external brain. That's so true.
When a caregiver has slept 4 hours in 3 days, they can't remember the exact dosage of an experimental drug, let alone what an institutional review board is. The binder remembers for them.
So empowering the caregiver with these tools isn't just about being organized. It's literally a matter of preserving the truth before the system erases it.
It is turning love into disciplined action. A caregiver with a well-organized medical binder and a firm grasp of their legal rights is the ultimate defense against that moving conveyor belt we talked about earlier. They're the ones who know exactly when to pull the emergency stop cord.
So why does this matter to you, the listener? Why should you care about a rare cancer case in Los Angeles?
Because the institutional clock is waiting for all of us.
Exactly. Don't wait for a crisis to audit your own readiness. Do you have an advance directive? Does your family know if you want an autopsy or if you want your tissue donated to research? Are your digital passwords secured somewhere safe?
Do your loved ones know exactly where to find your paperwork and, more importantly, who you actually want in charge of executing those wishes?
Yeah.
I want to leave you with a final thought to mull over. We are entering an era of incredibly advanced precision medicine. Our biological data, our genomic profiles, our tumor tissues, these are becoming staggeringly valuable to science.
It's the literal currency of future cures.
Yes. We spend our whole lives planning meticulously for who inherits our money, our cars, our houses. We write ironclad wills for our financial truth. But almost no one plans for who inherits their medical truth.
Inheriting medical truth. That's
Yep.
profound.
Will your post-death medical data, your unique biology, be your most lasting legacy? And if so, what moral obligation are you leaving your family to protect it when that vault door starts swinging shut?